Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. Every now and again, I come across sort of a piece of subject matter that when you get into a deep dive of it, you actually end up finding yourself confronting pretty fundamental doctrines of law, sort of notions of law, philosophies on law that you wouldn't at first think that would be where you'd end up when you sort of start the journey, if you will, of doing the research on a given topic. This kind of happened to me with the issue of vaping. I had recently a friend brought an article to my attention regarding vaping specifically, and we made a video on it. Basically, it's not as cut and dried as originally thought regarding the illegality of vaping in Thailand, most notably that while maybe possession while in Thailand, or if you buy a vaping product in Thailand, albeit illegally, but you're possessing it, that may not be a criminal offense. But again, the Customs Act in Thailand continues to make importation of such devices illegal. We've done another video on that topic contemporaneously with this one, not really going into that. What we're talking about here is getting into this, I bumped up against what we've discussed, and we primarily discussed it in the context of a bunch of the quote-unquote mandates that we dealt with back in 2021, where we went through the public health, I believe it was the Public Health Act, or the Communicable Diseases Act, actually I think is the title of that act, but off the top of my head. And we were discussing how there was, for example, no mask mandate specifically codified in any legislation, and as a result, I had serious questions about whether or not any sort of mask mandate was legal. Because quite honestly, it wasn't. Not to mention the fact that now, based on the data and the evidence, it was also ineffective, and that's pretty much unquestioned now by peer-reviewed, documentation that I've read. Leaving that aside, the issue of codification is not a small one. And although we're discussing this in the context of vaping, I think it's an important point to kind of draw out so that people understand. Again, I come from a common law tradition. I have a JD, at the end of the day, that's a doctorate. I've done comparative law. And then as I went along in the past 15 years out here in Thailand, primarily starting with U.S. immigration work, I got into dealing with stuff under the U.S.-Thai Treaty of Amity. And then as time went on, I became Thai, and I've worked with Thai attorneys over the years. I'm managing director of the firm here. I've gotten to kind of have a bit of an outsider's perspective, if you will, on a civil law jurisdiction such as Thailand. But this doctrine of codification keeps coming back up. I keep bumping into it, and it's worth noting. I thought of making this video after reading a recent article from coconuts.co. That's coconuts.co. The article is titled, "No, Vaping and Vapes Are Not Illegal in Thailand. Here's Why." Again, the thrust of that article is about vaping and sort of the nuances surrounding the laws on vaping and illegality. And this attorney that we're going to get into that's cited in this article notes that vaping itself in the country is not illegal, although importation might be. But what we're getting to in this video is something deeper. This is like philosophy of law kind of stuff here. This is comparative law, and I want to quote this. So, quote, "To prosecute someone under criminal law, there has to be a clear law," he said. And he is attorney Sukprem Sakdecha, a partner at Bangkok legal firm WSR International. So the Coconuts here is interviewing this person, this attorney, Kun Sukprem. And again, I want to quote this again. Quote, "To prosecute someone under criminal law, there has to be a clear law," he said. "There's nothing in the law which says that having or being in possession of such goods is in violation of the law." Yeah. That is codification at its core. And again, this is kind of where the legal philosophies, there's sort of a fork in the road between the common law notions of law and the civil law notions of law. Again, very basic stuff here, and I want to be clear on this. This is kind of for educational purposes only. Don't go out and be doing a bunch of things that are going to get you sort of apprehended by the police so that you can then have a detailed philosophical discussion on the differences of law. That's never a good idea. But this is more so that, in my opinion, I'm hoping this will be somewhat useful for foreign nationals who come to Thailand, especially foreign nationals coming from common law jurisdictions, to better understand the philosophy of legal thinking that prevails in Thailand. And this doctrine of codification is right there. Common law jurisdictions, they have an element of the civil law insofar as they oftentimes will promulgate statutes. For example, in the United States, we have a U.S. House and a U.S. Senate, and we have 50 state houses and senates, or a unicameral legislature like I believe Nebraska has in that one specific instance. But those legislatures promulgate statutory law. That's very similar to civil law insofar as you have codes. A legislature, a parliament will promulgate code and then promulgate laws, possibly regulatory code springs therefrom. You deal with it. But in the common law as well, there's a tradition of using legal opinion through the doctrine of what's called stare decisis in Latin, or let the decision stand in English, which basically is the notion of precedent, what we call precedent in the common law. And precedent is the reason why certain holdings in Hadley versus Baxendale, if you go back hundreds of years, or Blackstone's legal opinions, still hold weight today and have heavy weight that they hold today oftentimes because of the notion that we want to kind of keep an ongoing uniformity to the law. We want to keep these opinions we want people to have some certainty when they operate in the world from a legal standpoint. Now, Thailand, again, does not, and most civil law jurisdictions do not adopt this kind of framework. They're in the same way, I should say. It's my understanding in Europe, they sometimes do this with commentary, but Thailand's a different animal. The civil law system here, from my observation, does not seem to operate that way. Instead of having these sort of legal opinions, again, like a Supreme Court decision, just sort of hovering around in the legal mist, if you will, this sort of legal ether. Instead, the civil law says, look, unless something is explicitly illegal, you've codified it and said this behavior, this activity, this product is illegal. No one can own it. No one can do it. No one can whatever under these circumstances, and they're set forth in the law. Under the doctrine of codification, the presumption is then it's not illegal, essentially. It's only illegal if codified as such. That's how I have always understood codification. I remember going down to Louisiana years ago, a few different times, Mardi Gras a couple of times and things, and I always found it fascinating. Louisiana operated with a very different paradigm. It just operated kind of differently. And anybody that's ever been there, and folks that sort of know the legal tradition of America, know that Louisiana is an anomaly of the 50 states insofar as it is a civil law jurisdiction. Again, not one I have any great insight into, but just anecdotally I can say it kind of runs a little differently down there. And again, I think a lot of this stems from this doctrine of codification. So to sort of wrap up, and the thing to take away from this video is this is important stuff. As noted in this article, it has day-to-day practical ramifications that, look, unless you make a law that explicitly illegalizes something, you can pretty well presume that you can go ahead and do it without any kind of legal repercussions.